And if I had to be another person to stand up, if I think, after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. Just feels like no one else wants it.
Now, just because you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. Good evening, everybody. Welcome back into Let's Talk Live here in the LTL Media channel. It is Good Friday, and happy Good Friday to all of you. And thank you for joining me this evening for our first episode here on this Friday night of Friday Night Heat here on LTL. I'm really excited to kick off this first episode tonight. And I'm glad that you all can join me this evening. We have some really exciting things to go through here. Something pretty cool that may happen on the channel tonight. Ever so close to 40,000 subscribers. So maybe we hit that mark tonight and we can all celebrate together. We got quite a while here, so maybe we can draw in. I think the last number I looked at, let's see, we're currently at 39,918. So tell your friends, your brother, your sister, your mother, your dog. Let's get this stream out there and bring in some new subscribers tonight and get to that 40,000 subscriber mark. You know, it's funny. I was listening to the intro. Sometimes I just let it play, and I'm kind of thinking the show format at the very, very last second. You know, but Karen says out there on those courthouse steps, you know, we are the only ones that are fighting for John O'Keefe to find out what happened to John O'Keefe. And we are the ones here that believe in Karen Reed and believe scientifically that she did not hit and murder Officer John O'Keefe. It's not possible. And I've been saying this for quite a while, probably almost since day one, since I heard about the ARCA experts. ARCA is the case. ARCA definitely is the case. And the Commonwealth and Hank Brennan, they're shaking in their boots. We just saw this in the previous hearing here just a couple of days ago. Hank Brennan literally throwing a hissy fit in the courtroom. Again, to try to snuff ARCA out. Let's get ARCA out of here because he knows at the end of the day that is the case, because ARCA proved that Karen Reed did not hit Officer John O'Keefe, and Officer John O'Keefe did not make contact with Karen Reed's vehicle that night. And then we can look at all of the other things that are in between. 2:27 a.m. Google search, Jennifer McCabe. Brian Albert doesn't come out to his house. They rehome Chloe the dog. They replace the flooring in the basement as they sell the house just a few months later. The evidence is there. The evidence is there that something happened to John O'Keefe when he went inside that house that night. And the only people that are responsible to know what happened to him or the people that were inside 34 Fairview that night. You know, we hear Hank Brennan saying, oh, we welcome ARCA. You know, we want ARCA to testify. That's a deflection. He knows that he's afraid. And he knows that they have the goods. And then we just heard about Garrett Wing. Garrett Wing, a canine expert with many, many years, I think over at least 20 years experience of training canine dogs, will be able to testify to the wounds, to the dog bites on John O'Keefe's arm. It's another check for the defense. And I'm just waiting, absolutely waiting for the defense to mop the floor with the Commonwealth. I want to bring up this tweet. I should have pre-staged this before I went live today, but I want to bring up this tweet. And this was by the DUI guy. And today he put a tweet out. He said, who's excited for the opening statements on Tuesday? And I tweeted back and I said, I'm definitely not excited, as Karen Reed should not even be on trial for the murder of Officer John O'Keefe. We all know who should be. But I'm curious as to how the Commonwealth will present the evidence and how the defense is going to mop the floor with the Commonwealth. And that will happen. I think it's going to be no holds bar this time around. I think the defense team was a little too nice to let that in trial 1.0. But this time around, they will be ready. There's more discovery. And we'll be curious. Maybe there's previous discovery that wasn't used in the previous trial that we will now hear about. I'm telling you, my friends, there will be some mouth-dropping moments in trial 2.0. I can guarantee you that. We got plenty of them in 1.0. You'll hear Hank Brennan tonight in his presentation when fighting back about the ARCA witness that this is a trial by ambush. Really, one should talk. One should talk. Because Karen Reed should not be sitting at that table, that defense table. We know who should be sitting there. And I love that AJ I love the kind of put this phrase out, and we'll hear this tonight during the court hearing as well. What's good for the goose is certainly good for the gander. And I truly think that we're going to get a lot of goose and gander in 2.0. All right, let me check in here with the chat, see who we have hanging out. We have GA Hello Kitty has become a new YouTube member. I appreciate you supporting the platform here. We have Lindsay in the chat. Hey, how are you? Sandra says, yes, 40,000 subs tonight for sure. Let's do it. I'm ready. I want to get it. Lisa checking in. Happy Friday to you too. Happy Good Friday. Dina Jam, a channel member and moderator, says, thank God it's Friday. Like that. Hello. Hello, Lucy. Hello, Debbie. Dreamy's checking in. It is Good Friday. Thank you. Love the suit. Thank you. I got my Metallica and Justice for All t-shirt on tonight. And Justice for All. Scott McGinnis checking in says, I will be boots on the ground along with my brothers and sisters. Nobody will stop us, even those who gone astray. And I will be checking in along this trial, some boots on the ground coverage as well. Scott, I can't wait to be out there and see you during the trial. Excuse me. Debbie's checking in. Hello. Queen of Olives checking in. Thank you. Sophie's here. Nice to see you as well. New subscriber here, Abby Bruce. Thank you for checking in on this live show. Friday night heat tonight. We're going to bring the heat. We're going to bring the heat tonight. Lindsay says, ARCA daddies, bring it home, baby. Yes, the crash daddies. The crash daddies. Love it. Jones checking in. We have May checking in. Cindy's here. Long-time subscriber, long-time watcher. Good to see you. Yes. Teacup. I love this too. Every time he says, I have no issue with so-so, it's followed with a reason And he's an angry baby about it. Yes, he's a crying baby. We're going to hear a lot of crying tonight. All right, let's get to this hearing. Let's go through it. We have D checking in here on Twitter. You can join us on YouTube. It'd be great for you to pop over here on YouTube. Absolutely. Shella says, let's go. All right, let's bring up this hearing. We're going to go through the Karen Reed most recent hearing. Tuesday's the big day. We're going to be hitting opening statements, and I'm just going to really be curious of how Alan Jackson's going to open with the defense's opening statement. I know you all are too. My question is, the theater that we've been seeing from Hank Brennan outside of the jury's been picked. They are ready. Outside of the jury, all this theater that we've been seeing inside of the hearings, does Hank Brennan now change his personality in front of the jury? Does he start acting like a good boy? Or is he so fiery, it's so hot inside because he knows that he's going to lose, his temper, and it's going to show to the jury? And how will that play? How will that play? Let me know in the chat how you feel about this. All right, let's bring some heat. Let's go through this most recent.
All persons have any business before the Honorable Beverly County Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard.
I will boost the sound.
The Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lally for Commonwealth. Morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning.
Super chat coming in. Thank you so much. Says Flipper had just revealed his face on Auntie Bev's live, and he's hot just saying, well, if you think he's hot, good, great. But thank you for letting the ladies in the room know. Thank you for letting the ladies in the room know.
Your Honor, David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive.
If this just tells you right here, what's going on in this case, I mean, we've seen this through this entire process for the last 2 years, destroying discovery, not doing things under protocol, sending in more discovery days before a hearing, pages and pages, data and data of discovery to the defense team. They're still receiving discovery till up to today. It's insane. If you can't get with people, if you don't know what's going on here in Canton, I mean, all the signs there, they're all written on the wall here, what's going on.
Damage has been done. It can't be rectified. But there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
And here's the thing about the Sallyport video. We're never, ever going to really, truly know what is the true video because it's been, I mean, we found out it's been cut up in 6 different videos. We know that there's like an hour of it missing. We see it spliced together. There's apparitions. There's fucking Casper the Ghost that's popping up everywhere. Things are reversed. Things are upside down. What is the Stranger Things? The upside down, right? I mean, it's insane. We're never, ever going to truly know what the original Sallyport video. It's gone. Believe me, it's gone. You're never going to get it. You're never going to get it. It's been virtually erased and cut up into little pieces. And like Liza was saying, I mean, we're never going to really truly know where the metadata is on all these files. Exactly.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department.
Difficult to follow. Here's the thing. Don't drop and drag the files. And then what do you do the next day? Don't drop and drag the files because it could destroy evidence or metadata. And then what do you do the next day? You drop and drag the files. How is that hard to follow, Mr. Brennan? How is that hard to follow?
Bring their expert, download anything that was on the DVR, which nothing existed. And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically
I love
image
this.
Canton Police Department detective file? Because we've been denied that request. in the
Okay, so
past.
I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion, we're
So
going.
you're going to hide behind privacy. Oh, well, it has private information in there. So you're going to use that tactic and hide behind that
Do
bullshit.
is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between Commonwealth.
Right, but we have to make arrangements. So that was something that I asked you to figure out. You say Ms. Reed wants to go in the view. She can go in the view. How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors. But just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed,
That's
and the
fine.
rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they
They
decide,
want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but that's that request. I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway?
Sorry. I was talking about when they bring Karen's SUV over to 34 Fairview. Remember last time when they did the viewing, the tail light was completely removed. So, I mean, it actually made it look worse. You know, like the jury is not getting the actual look of how that vehicle was when it was manipulated inside the Sally port. They took the whole tail light out because it had been smashed into 72,000 pieces and sprinkled all over Canton. But you're not even giving like a full view of the vehicle to the jury. You move parts. And you're on a sidebar. I'm going to speed up, obviously.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that appear on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court.
Sidebar checking in saying, remember when I first started watching you had just made it up to 14,000 subs, and look at you now, kid. Well, thank you for checking in. I appreciate it. And it's been quite a journey. It's been quite a journey here. And really what's, pushed me to continue doing this is obviously all of you have pushed me to continue to do this and better my craft and get better and improve things that are around me, making sure that I'm booking those great quality guests that come here on the channel to give their expertise and to entertain. I don't know. It's just been, and people keep coming to the channel. So that just shows me that there's interest out there for this platform and what we can continue to do here. And I think that I have the potentiality here to keep raising the level of this platform and keep going forward, long beyond all the cases that we do cover. I think there is something there. I truly believe in this. I believe in all of you. And it's been a pretty damn amazing experience. So maybe we get to 40,000 subs by the end of this stream tonight. But thank you so much for checking in. I appreciate it. All right, let's keep going here.
Which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank
Thank
you.
you, Your Honor.
Okay. So Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
She should be here timely. Thank you. What I just remembered too, and this kind of brought this up, where MG just says always interrupting Alessi. And I remember during the ARCA battle back and forth when AJ and Hank were going at it, he insults Mr. Alessi and calls him Alisi. And then AJ gets up and corrects Brennan when he starts to start his rebuttal. And you'll hear that. Make sure to smash that like button. I would appreciate it. And if you're not subbed here on the channel, let's get subbed up. We're at 39,939. So we need 61 great individuals to come over and join LTL this evening. All right, here we
The defense
go.
proposes Mr. Wing is a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not.
Nor does Crosby have expertise on dog bite impressions. So I'll just add, I'll add that in. But I tend to like Garrett Wing's credentials versus Mr. Crosby, the behavior, the dog whisperer, the behavioralist, the YouTuber.
I'm a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite.
Thank you so much.
It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes to, and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
I'm just going to pop this up real quick. We have Digital Lee. Thank you so much for gifting 5 memberships. So welcome in new members. I try to do a members only like once every 2 weeks. And that's time for like Q&A. It's a lot more relaxed. We have a lot of fun on those behind the scenes type of member only streams. Annie from SB's member for 11 months, almost a 1-year member, says, I'm so happy that you are on tonight. Poor Hank. Poor Hank. I love that. And I'm happy to be here too. Again, this is the first episode of Friday Night Heat. And I want to make this kind of a theme going on throughout the trial. So I think, my theme here is what I want to do is, maybe over the week on Friday nights, we go through and discuss some of the more spicier moments during the testimony during those weeks. We can pull up some clips and discuss those as we go through. That's kind of my vision for Friday Night Heat. So I think it's going to be a lot of fun. And we can do that. Lauren DC checking in. Thank you so much. 6-month member. Appreciate you so much for being. I met Lauren through this movement, through this channel. She was the first person to actually bring the Free Karen Read movement to Washington, D.C., to right out in front of the White House. She was the first one to hold that stand out there. We met through, basically, she checked in with me through that process and through that standout. And we've developed such a great friendship over these last 6 months. And she's been my co-host here on Sundays and has been kind of a very, very good friend of mine that I could lean on and in time of need and frustration and happiness. And she's been kind of like an angel on my shoulder and given me some great advice and just truly listens and offers great feedback. And she is someone that has continuously pushed me on times where I've literally wanted to just quit and walk away and give up. And she continues to push me and says, you know, hey, you really have something here. Keep going, you know, because she truly feels, you know, long term, the longevity of the channel can be there, and this platform, you know, can grow. And again, I appreciate you and appreciate all your dedication and hard work of things that you've done here to help out on this channel as well too. It's been unprecedented, so I appreciate that. Let's see, Root Beer Float. Oh, what a cool name. $5 super chat. Thank you for being members. Just hit that subscribe button. It's free. Let's get LTL to 40,000 on this stream. Let's all be here for it. That will be pretty badass if we can do it tonight. I'm getting pretty close. Well, let's do a sub count here. We are at 39,949. So we need 51 new great people to come over here and smash that subscribe button. Victor said, just subscribe. Thank you, Victor. I have plenty of content on my platform. Karen Reed related, Idaho 4 related. I think I have well over 500 videos of Idaho 4. That is a case that we'll be jumping back here on the channel here as well. Joan says, let's celebrate at the Red Rooster. That would be great. Jessica Lynn, thank you for becoming a new member. I appreciate that. And I think we're going to hit it tonight. We just got to keep, we got to keep smashing that like button and get this out in the algorithm. All right. Enough of a pause here. Let's get back to Mr. Alessi.
So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right. That has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold technique, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment. The report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report. And in addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court schedule and other matters. Given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sir rebuttal, but as part of the defense's case in chief. And it is.
Welcome to the show, Lauren. How are you?
I'm good, Brian. How are you?
So you're getting ready to go on a little vacation here pretty soon out to the West Coast.
Yeah. Well, first, I just want to say thank you for your sweet words. That was so nice of you. I really appreciate your friendship too. And yeah, I just finished packing. I have an early flight to San Diego in the morning. So
Nice.
I probably won't stay on too late because I need to get some sleep, but I wanted to check in since I won't be here for the next couple weekends.
This case is so wild. It's so wild because I'm sitting here and I'm like, all right, Garrett Wing, you know, how do we first discover Garrett Wing? I almost said Ring. Melanie Little's channel. It's like over a year ago. And he may be called to testify. What's that?
Isn't that crazy how he was on a YouTube
as an expert for Karen's defense? I'm just like, how does this shit happen? You know,
Yeah.
I look at like, you know, Todd McGee. You know, Todd McGee, how I found him was through a PBS special about Karen Reed when he was
Mhm.
giving his opinion about it. It was a great, like 35-minute video. I did like a reaction stream over it. It was a very successful stream. And then a couple of weeks later, he was like in my studio, and him and I are just like great friends now. You know,
Mhm.
there's been so many positive things that have come out of this. I mean,
Yeah.
in this kind of bubble that we've kind of all created. And thank God, because
Mhm.
as of today, we are the anniversary, 2-year anniversary, April 18th, when Turtle Boy dropped the Canton cover up
Mhm.
article, part 1.
Mhm.
Thank God for that article, because if that would have never happened, and even Alan Jackson has personally said this to myself, this case would be completely different for Karen. The public support would be completely different.
Absolutely. Yep.
And
Turtle
it's
Boy
been
is the reason it took off.
such a wild ride. Absolutely wild ride. I mean, I've been through I've been through the best of things, and I've been through some of the worst of things here too, but the
Mm.
best have always outshined the worst. And
I
you know,
agree.
we always manage to rebound and pick ourselves up off the floor and keep going and have that courage to, you know, keep continuing to stand for Karen and be a voice in this movement, and, you know, just continuing to keep things going and educate people and let everybody know about what's going on here in Norfolk County.
Yeah. Like you said, there has been a lot of good that's come out of this, and I think that in order for all of us, but especially Karen, to get through this, you have to find the silver linings and the positive things, you know. Like you were saying earlier before I came on, I decided to do a standout in front of the White House because I was living down there at the time. And I messaged a few creators just hoping to get a little bit of visibility so people knew what was going on. And if anyone was in the area, they could join. And you got back to me, and like now we're really close friends. So
Yeah.
it's crazy how things happen like that.
I've met some really great people through
Hmm.
this. It's changed
Me
my
too.
life.
Yeah.
It's
Yeah.
changed my life. I mean, I have a whole new circle of friends and, you know,
Hmm.
outreach, and, you know, I would have never known, you know, that
Yeah.
be in this situation, but there was a calling for it. And
Yep.
we've all been called upon to be here in this very moment all together. And it's wild. It's really
Yeah.
wild. I sit back some days and I go, really? Like, this is
Yeah.
happening? You
I
know?
mean, this goes even deeper than just Karen's case and Sandra's case. It's exposing corruption on the deepest level in our government. You know, it's what we're doing is important work.
It's waking people up, I think. And I think
Yeah.
a lot of that started kind of right around the COVID time, when everybody could
Yes.
stay home and start looking, you know, from inside out. And I think some
Yes.
reality started to hit people, you know, because they had time. That's all we had was time. We had time
Yeah.
to actually sit for a moment and listen to the silence
Yeah.
and start looking and going, all right, some shit doesn't add up here. And
Yeah, I think, like you said, everybody had a lot of time on their hands, but also I think the way, you know, COVID changed the world forever. Nobody knew how to handle it or what to do. And I think it brought a lot of things to the surface that people on a daily basis wouldn't have seen before.
yeah.
But it brought a lot of things to light. So the world definitely changed because of COVID and now because of Karen's case.
Mhm. If we have a bunch of new people checking in here tonight for the first time, so we want to welcome in all our new subscribers here and chatters here. My panel that's on my guest on panel right now is my good friend and co-host on the Super Sunday show. Her name is Lauren DC, and she helps me out here on when we do our live show on Sunday and we take live calls. Unfortunately, she's going to be out of town for the next couple weekends. Going out to the West Coast, but she wanted to jump on tonight and just say hi to everybody as she's going to be out of town. Let's see. KK says excited to make a live with you. All right, let's go back to the hearing. If you want to comment, Lauren, just say stop. If you want to make a comment, We are close. Let's do a refresh here. Right now we're at 39,968. So if my dummy math, what's that? 22? No, 32 people. Need 32 new subscribers tonight. I think I got my math right?
You said it's 60. How many?
I got 39,968. So 32, right?
32. Yep. I can't do mental math. So, but yeah, I just use my calculator.
Pretty good. All right, let's get back here. I think we can get 32 people in the next hour or so.
Part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear next.
Understood. And I was just...
To let everybody know, that's not my stream. That was the court stream. That's choppy. So it should iron out here in a minute.
Going to say, I am not going to get into the basis for that. I just wanted to, because...
Just go ahead. Just move on.
Yeah. So my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly.
I think that's a great point that Bev is bringing up. And I think that's been kind of the conversation amongst all of this. Crosby says he went out, got these mouth impressions, teeth impressions of Chloe. How the fuck would we even know that that's the correct dog? Like, how would you even know?
Until they produce evidence that Chloe is alive and well, it means nothing.
It's never going to happen. You know that, and I know that. It was probably some fucking dog that like, his neighbors, hey, can I take an impression? Like, you know, it is... NH Dude 603, thank you so much for becoming a new YouTube member. I appreciate that. I mean, there's no way that you're ever going to prove that these bite impressions came from Chloe. I mean, it's fucking no way. It's no way. Yeah. Like Scott said, Chloe is dead. They snuffed that dog out.
I unfortunately agree.
Yeah. And it's terrible because if they did kill a dog, not only are they fucking killed a Boston police officer, they killed a dog as well. It's pretty sick. Pretty sick.
Mm-hmm.
All right,
and I'm pretty sure that dental impressions of dogs is junk science from what I understand too. It's not even like dental records for humans is pretty reliable, but from what I understand, it's not a very good science for dog like impressions.
Well, there was a post, I think, in the Justice Group about that today. And I kind of scanned it. I saw someone showing some measurements in a conversation that they had with a veterinarian about dog bite impressions and like, that they would change over time as the dog grows, where I think a human's mouth, and I could be wrong here, I'm just kind of saying this, I think a human's mouth at certain time tends to like kind of settle and not grow. I think we get to a certain point of where that is, and I could be wrong. I'm not a doctor. But
Yeah.
I think I remember reading and looking at something up about that. But dogs' teeth are always changing, apparently, and their jaws grow and stuff. So
Yeah.
anyway.
Most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
So I come corrected. Joy says it's not good science even for humans. I have bite impressions at my house because I've done a shit ton of dental work, and I have all my little castings that they've done. It's pretty cool. You know, I have all those.
I could see it being unreliable for humans too, though, because, you know, your teeth do, like if you had braces and then you stop wearing your retainers, like your teeth shift and, you know, you might lose teeth or something. But I think it must be reliable enough that they use it to identify bodies.
Yeah.
So I don't know.
I'm not going to get into that. I'm not a doctor. I'm not going to get into all that stuff. But you know, I digress on that subject. Graham, thank you so much. Check out your new sub. Thank you for being here. Lauren, we're very close. We're at 39,974. So need 21 good people just to click that subscribe button. We'll get to 40,000 tonight and celebrate. And then we'll move on and we'll look forward to 50 and 60 and 70 and 100,000. I want that play button.
Yeah.
There's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you. I'll tell you that. I'll hear from Mr.
Oh, she kind of cut him down there. She was
so sassy.
I gotta say, this hearing, she was doing a lot of things for the defense, a lot of positive things, I have to say. And she just fucking sassafrassed him. It's an uphill battle.
Yeah.
She sassafrassed him. All right, let's hear Mr. Blessy.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's question, comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
You're getting close, Lauren.
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Real quick, is Nick Rocco checking in. Hello, Mr. Nick Rocco. So let me just say, while I was with Alessi the other day, the amount of thought I had to put into my response to him in a conversation was crazy. I didn't want to sound dumb. I love that. I love that.
Sometimes you just meet people who are so smart and you're like, I don't want to say anything stupid.
Yeah, I don't want to say anything.
Yeah.
But you know what I love, the interactions that I've had with Karen's team is that they're so receptive to everybody. They don't look at people on different levels or skills or whatever. They are just so respectable and so receptive to conversation, and they give you an answer. They listen to you, and they will have a full-on conversation and answer your questions and try to make it very clear for you, like what's going on. I had some questions that I need clarified when I had the opportunity to meet Mr. Jackson, Mr. Unetti, and Ms. Little that time when I got to sit in the court, and they were so gracious and answered my questions. And that's like awesome. That's really, really, really awesome. Let's see. Nick says, Alan Jackson's my new dad. I love that guy. So nice. Such a nice guy. All right, Lauren, let's go.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist. Is there any objection to the substitute chemist?
So close.
Commonwealth's motion
11
663.
more.
No, Your Honor.
Okay, so Jim 63 is allowed.
Yes, Your Honor.
Let's see. Norman Corey's $5 said, how did they get the molds from a dog that is not good with strangers? Did they knock it out? I call bullshit. I mean, it's complete bullshit. You know that, and I know that. What was it? Documented 2 separate attacks on 2 different animals. Oh, and I love going back to the May 5th hearing that we just went through, 2022. Alan Jackson goes, and they even say when people come over to the house that our dog's just not, what did they say? He said, our dog's just not good around people, which means the dog bites.
Yep.
Which means the dog bites. Because I've heard that before. The dog is just, I've gone to people's houses. Hey, you can come over. Just, listen, my dog's a little erratic. It's not good around other people, which means it's going to fucking bite you if you go to touch it.
Pretty much.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
9 more.
Commonwealth agrees to
9
give
more.
notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
Hi, Your
going on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know what will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay. Thank you. Can I have the defense what you intend to put up?
Oh, look at this.
Photograph, Your Honor.
He has a media checking in. There he is.
Hi,
There
Maz.
he is.
Hey,
Love
Mazza.
Brennan. Love Brennan when he used to use when he used to do voice work for The Simpsons. Sherry Davis checking in, new member. Thank you, Sherry, for becoming a new member. I appreciate that. You have all that members only content to indulge in on my homepage. So make sure to click that, go to the bottom of the page, and you'll see it down there. All right, Lauren, we're getting close. We're getting
so
close here. We're at 39,994. I think everybody's pulling out their sock puppet accounts tonight.
I already subscribed with my sock account a long time ago.
everybody subscribe with all your troll accounts. Let's go. Let's get this done.
I'll provide it to the court immediately after the hearing.
Okay.
No, I'll add that there are a number.
I have no speech. I really don't. I mean, I don't have any. I have no speech. You know, but I just have to say, it's a. I like numbers. I'm a numbers guy. I think it gauges performance. It gives you goals to stretch for and reach. I know people get like, oh, you're talking about fucking sub counts and stuff, but it's a proud accomplishment to say, hey, you know, I had 40, you know, I'm close to having 40,000 people kind of hang out on this platform. It's pretty cool. You know, it's pretty cool. So let's see, a little refresh here. Maybe we're at 39,998. 998.
Proud of Brian. So fuck anybody. And that's the first time I've ever sworn on this show. I try to be clean when I'm on YouTube, but fuck anybody who's like, oh, the numbers, blah, blah, blah. No, you should be proud. You've worked hard.
We all have. You know,
yes.
Listen, to make a YouTube channel run and work, it's, yes, I'm the host. I create the content. I come up with the ideas, but if the subscribers don't come around, your channel doesn't move through that huge algorithm. And there's billions of channels on this algorithm in this space. And I've always said that it's a community thing that makes these channels go. It takes everybody. It takes members. It takes subscribers. It takes moderators. It takes friends. It takes experts. It takes a community to make this happen. And you know, I am super, super appreciative. I've been here 5 years, and I'm gonna tell you, getting subscribers on YouTube is fucking hard, because I'm gonna tell you right now, I just proved it the other day. Over the last 28 days, 63,000 new viewers have come to my channel but not subscribed. And that's very typical. That's very typical on this platform. But if I can just get those 63,000 to subscribe today, we'll be at 100,000 by the end of this stream.
Ryan, refresh your page. People are saying
do a refresher right now. All right, so we are at 40,012. So thank you so much. I appreciate it. Let me see if I can get my applause button here. Here we go.
Woo! Congratulations, Ryan.
Thank you.
That's great.
It's been a long road, and it's great. And like I said, if I would have gave up, you know, years ago or months ago or whatever, I wouldn't have met all of you. I mean, I've had the pleasure of meeting a lot of these people in this chat room. You know, I've met you. I've gotten to meet Mazza and Nick Rocco, and you know, I've been privileged to be able to go and rub shoulders with Karen's defense team and kind of be in the mix of all this and kind of tell the story of Karen Read through the lens of my eyes, you know, and I'm so appreciative for that. And I don't know, I'm just thankful to be here in this very moment, because I don't know what else I would be doing.
Yeah.
You know, I don't know what else I would be doing. So
you're exactly where you're meant to be. I have a sign right on my wall that says you are exactly where you need to be.
Yeah. And it's funny because you've been to the studio too. As you come in, there's a sign over the door that says, great things are about to happen. And then as you leave, there's the sign over the threshold that says, never give up. And I truly believe in that.
Yep.
So, but thank you all so much for being part of this experience. I mean, this is an experience, and I hope that, you know, we can continue this on down the road as things come to a conclusion and we get to, you know, digress and you know, talk amongst these things and continue to discuss them, because this case will be discussed forever.
Oh yeah.
This will be
They'll
discussed.
write about this in law books, probably. They'll talk about it in law school.
100%. All right, let's get back to the hearing. I know it's late, Lauren. I know you probably have to jump soon, so don't feel bad if you got to go.
I'm good for now.
What's that?
I'm good for now.
All right, we're getting pretty close to the fiery debate about ARCA, and it's coming up very soon.
For statements that we have clipped, we, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you want.
Thank you. So I need the defense to
get this out of the way. I'm sorry, we've been pausing a lot tonight, but hey, it's warranted. Norman Corey says it's $5. Said just subscribe on my wife's phone while she's sleeping. Thanks for the $5. The Goodmans $5 says over 40K, only up from here. Woohoo! You've worked so hard, and it does not go unnoticed. Goodmans, I appreciate you. You're ever so kind, always in my chat, dropping memberships to everybody, and it's been pretty cool. It's been pretty cool. But again, you can't do these things without the subscribers, the moderators, the support of the community. And I'm going to tell you right now, we're going to be planning a nice revamp in here with some new backgrounds, and you're going to really love it when you see what it turns out in here. I got a plan, and it's going to be really cool. So, Nelson, thank you so much for becoming a new member tonight. All right, let's get back to Friday Night Heat here. We're going to have some heat here in a minute with Pissy Pants Brennan, pouting like a 3-year-old about ARCA. Dr. Bob, look at this. Wow, Dr. Bob. Wow.
That's crazy.
How are you? First of all,
months.
I haven't seen you in the chat forever. I hope you are well. And look at this, everybody. Still a continued member and supporter. 25 months Dr. Bob has been here. 25 months. It's so good to see you. I haven't seen you in a long time, but maybe you've been kind of hanging back in the background. And it's really great to see you pop up tonight. And I have thought about you. So don't think that I haven't, because I have. And I remember you came around the channel in my Idaho 4 days. And I hope that you continue that journey with us, because we will be talking about the Idaho 4 case here. We will be going back to it. All right, here we go.
to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've put the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So, all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes,
So,
please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
I'm going to pause this. I got to go back to this because I'm going to tell you right now, I think Dr. Bob is probably the longest subscribing member here. 25 months. I don't think there's anybody that has outpaced him. I don't think so. He's local here in Massachusetts as well, too.
Oh, yeah?
I do know that because I've had conversations with him via email.
Well,
I think
you,
he's
Bob.
our longest standing member here on the channel, and that's has to be celebrated. So thank you so much. 'Cause I was just thinking about that. I'm like, he's got to be he's OG. I mean, he is OG. Yeah, Dr. Bob is like OG. He's the original gangster.
OG
Helen, thank
Dr.
you so much.
Bob.
Yeah. Helen, thank you so much for becoming a new YouTube member. Thank you, Microdots. I appreciate you. I appreciate you so much and everything that you do for this moment and those glorious, beautiful visuals that you put together. The talent that is inside your brain. I wish I only had a smidget of that talent. And you provide such great content and such a wizard with what you do. It's unprecedented. All right, here we go.
All right. How are you going to find this person?
But we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Thank you, Christy. Always in the chat. Another member. Thank you.
Brian, I'll be right back, but keep playing.
Yeah, take your time. Oh, we got a fan. Look at, we got the fan. We got a fan. Lauren with the fan. All right, let's speed up here.
Simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female, or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. It's I understood it to be to take out all influence.
I want to go back here in a second. I just want to pause this because I want you all to keep an eye on Karen's face here when Bev says it doesn't have to be a state trooper. She's obviously very flustered, and because Bev is pushing, Bev is saying, well, we can just bring people in to read it. I think it's bullshit because you can have deflection. You can have the tonality of someone's voice could sway a jury. I don't like that. I don't like it at all because you don't know how these people are going to present these text messages if they have just readers. Sandra Beatles fan, thank you so much for the 5 gifted memberships. But I want to go back. Yeah, let's bring a state trooper in. That's exactly what we don't need here. But watch Karen's face through this argument.
Male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent
Watch
people.
Karen's face.
Motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. It's I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
Yeah, and this is what I'm talking about. Tone does matter. tone does matter in this, because you don't know how these people are going to present it, and that could sway a jury. You know, if they start adding some emotion into it, or certain, I don't know. I'm not a linguist, but just changing things the way that the tonality of how they're reading these out. I mean, it can definitely change and put an impression on someone. Let's see this. Darlene D, thank you so much for the $10. Says, hey, LTL community, Brian, I'm a contract healthcare worker, and I'll be in Worcester from May to August. I'm hoping to make some standouts and meet my fellow Karen Reed supporters. I'm going to tell you right now, probably the best one to go to is Dedham, because it's the largest one, and you'll meet the most supporters there.
It's like the OG standout.
The OG standout. That's the one that I would meet. It's pretty accessible. You can go to Karen Reed standouts.com, KarenReedStandouts.com for the list of where all the standouts are, and I'll drop that in the chat if you want to add it to your bookmark. All right, here we go.
Thank you.
Oh, here we
All
go.
right, defendant's motion for specific discovery, paper 638, Jimmy. All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say as a preface that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of the witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan,
Real quick before they argue this, I want to go back to something really quick. And many months ago, I remember someone. This is really, I'm going to tell you right now, this is the reason that I've pushed on YouTube. It's why I've kept doing this, because in the little back of my head, I filed this all along. I had someone that I used to kind of pair up with in the kind of Idaho bubble, the Idaho 4 bubble. And this person, and probably people here in the chat, because I probably have a few of them here and they're going to say the name, used to, because we'd always have these kind of like competing streams of Idaho stuff, right? And this person said to me, or used to go on their channel and say, oh God, I can't remember what name I was at that time, because I've changed this name on the channel quite a few times, but we're going to stay with LTL. And this person said, oh, that channel, that Brian's channel is never going to amount to anything. It's never going to be anything. It's never going to be a big platform. And it was funny because as I was getting close to hitting 40,000 subscribers, I did it the other day. I kind of sneaked in and looked where they were at, and they haven't moved it much at all. Haven't moved. Their channel has not grown. And I laughed because I said, we're doing pretty big things over here. We're taking part of some pretty history making things. And that was kind of funny. So
yeah, look at you now.
Yeah, it's more look at us now. Look where the platform has grown. Because again, it comes down to everybody, the community.
True.
We've built a community here.
Yep, it's a team effort. You're
100%.
right.
it's not solely just the creator. The creator is one portion of the pie, but it takes a lot of people to do this. All right, here we go.
Regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses.
Here we go.
Motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
Oh, I love this part.
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start.
I'm gonna laugh here a little bit here, Hank. You're talking about, yeah, and yes, exactly. You're gonna have the balls and the gall to come up here and stand about and talk about discovery when discovery literally gets dumped in Karen Reed's team's laps on a nightly basis. They're probably still receiving discovery right now. And you're going to get up here and say, I'm upset at the way that the discovery process has been carried out by the defense pertaining to the ARCA witnesses. Give me a fucking break.
Yep.
Give me a fucking break. All right, let's hear him.
Ridiculous.
His hands here.
With the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history.
Are you taking selfies, Brian?
Suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not...
all the things that you continuously dump into Karen's lap on a daily basis, right?
Yeah.
Obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. we have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again, for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Here we go. Oh, here it comes.
I want to go in reverse order briefly, if I could, concerning the discovery deadlines. We have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA.
Can I just say
They filed
this?
their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case.
This is a very important point, because when the federal letters came out, when we knew about ARCA, when they were brought into these hearings and they were talked about, and I remember AJ saying this, the Commonwealth, Mr. Lally, didn't want anything to do with ARCA. They didn't want to engage them. And Alan Jackson right now is going to say, the minute we found about them, and the reason that the Commonwealth didn't want to engage them was because what happened? They proved that Karen didn't hit John, and John didn't make contact with Karen's SUV. Commonwealth wanted nothing to do with that. They wanted to run from that report.
Mm-hmm.
But the minute that this was released, of course Karen's team's going to reach out to them. And I'm saying this is the case. And this is the simple point that I make to every fucking troll that comes after me and gives this long diatribe about Karen's a fucking murderer and she did this and she backed over him and the wounds on his arms are this X, Y, and Z. And I just go like this. I literally just type ARCA, period.
Yeah.
That's it.
You don't need to say anything more than that.
That's it. I don't have to go into a long diatribe and say, no, there's no fucking way. Jennifer McCabe, 227. I don't have to go there. I don't have to go there. Just put ARCA to the reply. And they have no response to it. And Hank knows that too. Because the minute that these ARCA experts get back up there and tell me, they're going to be well more prepared this time around to present these two witnesses, to present ARCA. They're going to be well more prepared this time around. And Hank knows that.
Yep. I mean, ARCA was hired by the feds.
Yep.
And their PhDs, like, really? You want to compare that to the Commonwealth's experts? The pirouette, please.
Yeah.
Come on.
Yeah.
What a joke.
And I'm telling you, that's why he's pissing his pants here. And he's fuming. Because what has he been doing the whole entire time? Trying to get ARCA out of this case.
Yep.
All right, let's go back to the hearing here. By the way, I just want to do this. Tasha, thank you so much. $5 on Venmo. Said I can't afford much, but I truly appreciate your dedication and content. Truly pleasure watching your videos and live streams. Oh, so sweet of you. You didn't have to do that. All I want you to do is just be here and watch along with us. But I appreciate the $5. Thank you so much. That was very sweet.
Brian,
On
I'm
that
gonna
same
head out
day,
for 5
we
minutes.
contacted the Commonwealth. Actually, the very next day, we contacted.
I said I'm probably gonna give about 5 more minutes and then I'm gonna head to bed.
Yeah, I know. You got to catch a plane tomorrow early. Libra in Seattle, $2. Thank you. Says, congratulations on 40K. I appreciate that. All right.
Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith.
Real quick, I'm just going to pause this. Helen Lewis is $4.99. Thank you. Says, Brian, really love your channel. Enjoy your panels as well. The brother council was great. Thank you for all that you do. I appreciate that, and I'm going to tell you right now, I literally just said to Lauren the other night after that panel, I said, as far as hosting, I felt like that was my best hosting. Is that the word I'm looking for? Like,
Yeah,
best panel that I've hosted.
Yeah.
Because the flow was just ripping along. So I just felt like it was just like almost like a perfect panel for me. And it was a really great panel.
It was.
All right,
I agree. It was a great show.
Yeah. And it was someone asking me if I donate to Karen Reed's defense fund still. Yeah, I do. I do cut portions, and there's other things that go on that people don't know about. I mean,
Brian does a lot behind the scenes too.
Yeah, and I do. So real quick, Norman's Corey, thank you for the 5. Why does Hank just have why doesn't Hank just get a real accident reconstruction? Expect to say that he wants good luck with that. The thing is that Trooper Paul was the guy that I think was I think Trooper Paul was the guy that they needed, and they sat him down probably in a dark corner with a spotlight on him and said, you're gonna do this. That's how I feel about him. So anyway, here we go.
With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points they were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody control.
So for which ones? Which of your numbers?
Number 1, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address
Question. Calling speech therapy. You guys are awesome. Will the jurors be aware that this is a second trial? I'm pretty sure. Yeah, it probably will be brought up. I'm pretty sure it will, because you're going to hear rebuttal testimony. You're going to hear testimony from the previous trial when they have to go back and reference it. So they're going to say, in the first trial, you said X, Y, Z. So they're going to know. They're going to know that this is a retrial. Yeah.
I just want to say good night to everybody. I'm going to head to bed. I got to get up early. But thanks for letting me hop on really quick tonight. And I'll see everybody when I get back. I'm sure you'll still see me in the chats and stuff while I'm out there a little bit. But
yeah, let me know when you get out there and you land safe.
I will. I'm sure we'll text while I'm out there.
For sure. Have a good time.
Thank you. Have a good night, everyone.
All right.
Bye.
Bye. All right, let's go back.
number one, Mr. Jackson.
The number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
It's called
address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with...
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the biological side.
There was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Right. Ms. Lou I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. That is on.
Can they testify under what direction they did these things.
Well, they can certainly testify to what they did. Absolutely. That is on the table. Every bit of testing, every bit of analysis.
But why they did it.
What their communications were, what their directives were, that is confidential. And
Can I see Councilor Taggar, please?
All right, we're just going to speed this up, obviously, for time. How's everybody doing? All right? Hopefully good. Here we go.
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
that is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report. And that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice or the U.S. Attorney's Office was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were providing.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint. And we wanted them to have basically a mirror image of what Dr. Welcher was providing.
All right, so when did you do?
We provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion.
Okay.
Additional discovery for the experts for their review on March 26th, 2025. Okay. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
Oh, here we go. And I just want to pause here for a second again. I'm beside myself that Tuesday is going to literally be open statements for Karen Reed 2.0. Beside myself. It should not be happening. Shouldn't be happening. All right, everybody. It's the time we've been waiting for. As of right now, it was 10:40 p.m. here on the East Coast. Mr. Hank Brennan, Pissy Pants Brennan, here we go. Get your popcorn ready. Time for fucking full meltdown in 3, 2, 1. Yeah. Here we go. Look at him.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis.
You had the opportunity, or let's see, Lally had the opportunity to engage ARCA in the first case, you fucking dick. You guys didn't want to do it because you knew that it was against your narrative of the case. You want them to go away because this crushes your narrative of the case. Oh my God, he knows this. He knows that this is the case right here. And by the way, this is a perfect stop right here. Everybody that's been calling the student Quentin Tarantino, you've got to watch his face through this because I found it hilarious. This gentleman right here, and I'm sorry, I don't know his name, but I found his facial expressions hilarious through this. And this is such a perfect still frame here. But here we go. Let's listen to Mr. Temper Tantrum.
Of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled.
Oh, you're entitled.
The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a TUA request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructions they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a TUA request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses. They have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Okay, so now I got to ask everybody here. Do we get this version of Hank when there's a jury in the room. The jury's not there, so he can be wiling out all he wants. But do you think that we're going to get this same version of Hank when the jury's present? Or is it going to be all nicey, no more pounding, no more tapping the fingers? What do you think? Do you think we get, all right, if you think we're going to get this version, put a 1 in the chat. If you think we're going to get the kind of cleaned up version of Hank, put a 2 in the chat. Yeah, that's a good.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander.
Yes.
Mr. Brennan has been consistently providing us with new discovery.
There you go.
After his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody's at a disadvantage in this trial.
It's true. I mean, Jackson's basically saying that all the information was there. You didn't want to engage them, and we did. You're on an equal playing field. I mean, I love this explanation by Jackson. He's like, everything Brennan just said is bullshit. They had the opportunity to do this. Again, it didn't fit their narrative of the case because it proved that Karen didn't hit John and John didn't ever make contact with Karen's vehicle. That's it. So he's right.
We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
That's it. I'm going to piss his pants again.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welcher's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alesi, who is much more facile with the facts of what's in Judd Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judd Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left
It makes absolutely no sense.
Motion to
That is the
sequester
Commonwealth grasping at
Aidan
straws.
Canny from
If it walks like a duck
to remove him
and talks like a duck, it's a duck.
from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to,
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct, which we would need to provide. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan
I think this is about Proctor.
the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
all right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay.
Um,
You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway, so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right.
We won't be taking a 15-minute recess. Let's move up here. Here we go. Back to the hearing. We'll get ready to finish up here in a little bit. I want to thank everybody again for coming over and checking out the first episode of Friday Night Heat. My theme, if you all weren't here earlier, I think what I'm going to do for Friday nights is just take some of the spicier testimony. We'll clip it together and we can go over some clips and discuss it on Friday nights. All right, let's do this. It's going to get really interesting here. We're going to have Tim Bradle, who is Turtle Boy's attorney, is going to get up and talk about pleading the fifth. Aidan Carney pleading the fifth.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay,
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Bupnik, Detective Lieutenant Tully.
okay,
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
Okay, all right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So
Oh, thank you, Teresa. That's very kind of you. Thank you.
Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to,
And one thing I love about this too, when they put the graphic over, and I pointed this out if you're on Twitter or you're on my Facebook page, they say, attorney Tim Bradle, Turtle Boy's attorney, which I thought was great.
sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We've discussed, and there was an order on all of this.
Yes.
Are you asking that Aiden Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is
Now,
rebuttal.
what they want to do here is they're going to try to fictionalize. This is what I think they're asking. So, are you going to call him? Well, it just depends on the situation inside in the case. So, if the defense starts pushing hard on third-party culprit, they're going to try to. What they wanted to do was get Aiden up on the stand and basically say, well, you fabricated all of this and you fed all that information, and you and Karen Reed colluded on all of this, and you blew this wide open in this big conspiracy. That's what they wanted. This is what Hank Brennan wanted for Aiden in this trial, but it's just not gonna happen. It's definitely not gonna happen, and we'll play this out here.
The defense calls the defendant to the stand, then it is a strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate.
And this is just grandstanding right now.
Okay.
It's all bullshit.
All right, now I'll hear you, Mr. Bradle.
All right. Thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under
I think that's part of it, but I think there's other elements to this too. You have to look at it. The Commonwealth is set out to win their case, okay? And what they're saying here is that the Commonwealth's like, no, there's no third-party culprit here. No one inside the house killed John O'Keefe, okay? But who exposed it? Who told us the truth? Aiden. So they wanted that moment that if the defense in their presentation pushes hard on third-party culprit, they've already named who they are: Albert, Higgins, Colin Albert, Brian Albert, and Higgins. If they push hard, they want to get Aiden up on the stand and say, you fabricated all of this. You put all this together. You fed all this into Karen Reed's head. And that's why she's been using this defense. That's the moment they wanted on TV. Because he told the truth. He exposed the truth of what happened. That's the moment they wanted.
the government's
all the shit they're doing right now is it's Hank Brennan grandstanding.
The obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you.
And Hank Brennan is balking here. He would never put Aiden up on the stand. It's a balk. But let's just say even if he did, he just wanted that moment for Aiden to say, I plead the fifth. I insert my Fifth Amendment privilege. That's what he wanted. That's what he wanted. And he's not going to get it. He's not going to get it. It's total fucking grandstanding for these cameras. He wanted to insert this, but he wanted that moment in front of the jury. See? And look, he's pleading the Fifth. He made all of this up. You know, he's gathered all this bullshit together and wrote all these articles and fed it to Karen Reed so they could use this as a defense. That's what Hank Brennan wanted. Ain't gonna get it. Ain't gonna get it.
On that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Here we go.
Your Honor, you have questions?
Yes. What if he takes the Fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures that come.
And this is actually a good move by Bev, because when Brennan first got up and she said, what are you doing here? Are you calling him to the stand? Are you not calling the stand? She's basically saying, we're not going to play games here. So she listened to Bradel's argument and now basically is holding Hank to the carpet here and saying, what are you fucking doing? If he inserts his Fifth Amendment privilege, what are you doing? Let's just get this all out of the way right now. That's essentially what she's doing.
Could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But as a predicate, he would need to assert his Fifth.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client?
Specifically to Howie Carr. This is the same bullshit he tried pulling, and it fucking didn't work.
Sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel.
Fucking moment for Aiden to get up on TV and say, I plead the Fifth, and he didn't fucking get it. He didn't get it.
Staff work through lunch for a little bit? Yes. Everybody's done? All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Exactly, Norm. That's the way she's saying it. Listen, you're going to shit or get off the pot here. What are you doing? Let's just get this out of the way now. I'm not going to go through trial for the theater of this. Let's just do it now. I actually kind of love the move from Bev here. I mean, she kind of spanked Hank quite a few times in this hearing. All right, we're not going to take a break, and I don't think they come back. Do they come back? I can't remember. Right here. Again, I want to thank everybody for coming into this live stream today. We hit 40,000 subscribers here on the channel tonight. All the new subscribers that came in, all the new members, I appreciate you all for being here. And we got a long way to go. Karen Reed 2.0 starts on Tuesday. Again, I can't say I'm excited for it. I'm anticipating it. I want to see how the defense is going to tackle the Commonwealth this time and fucking mop the floor with them. Because I think Hank is going to end up losing his shit quite a few times during this trial. All right, here we go.
Session, you may be seated.
All right, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Carney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
oh, sure. Is there any objection for everybody hearing this?
There is. I would like Kearney to assert his fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel. And all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
Look how fucking mad Brennan is right now. Look at the body language. And that's it. They're going to just, that's it. They're going to insert his fifth and that's it. She's not going to do it in front of the camera. You got, let me see. Let me speed up here.
All right. So, Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would, in fact, invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something that we've done.
Right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants brief, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so vote, please.
That's it. That is it. That is it. That is it. That is it. Wow. What a Friday night. Friday Night Heat. Friday Night Heat. The first episode of Friday Night Heat. And again, I think my theme here, what I'm going to do is just throughout the week, if we have any spicy testimony, we can do those playthroughs on Friday and talk them over. I think there's going to be many, many of those moments throughout this trial. I really, really do. Probably mostly from Hank Brennan breaking down and losing his shit. He's going to have to be careful in front of that jury. But I don't know if he has the tolerance to do it. I really don't. Caroline, thank you so much for the $20 on Cash App. I appreciate that. Yeah, we got to 40,000 subscribers tonight. Really, really cool. Good stuff. Such an accomplishment. And it takes a whole plethora of people and a team to make a YouTube channel evolve. And listen, I really appreciate you all clicking that subscribe button, joining the lives when you can, and participating in the chat, because it makes it fun and educational. I learn so much stuff on a nightly basis. And I love the fact that people want to come here and hear my perspective on all of the things that we talk about here on this channel. And it's a group effort. It really is. I mean, you can't do this on your own. It takes a group of people to do this. And I want to thank all of my phenomenal guests that have graced this platform with their presence, their intuition, their expertise, their stories about life or situations that have happened to them. And, it takes all of those initial things to kind of come together and lead you down a path. And I think that we're truly on the right path. I really do. I think there's a large space for this platform as it continues to grow. And there's many other ideas that I have here that I want to do. And we're going to start making a lot of those things happen here pretty soon. So again, thank you all so much for coming and hanging out here tonight on this Friday night, the first episode of Friday Night Heat. I can't wait to do this. I will be back on Sunday for the Sunday Super Show. I'll be solo, but that's where we open up the phone lines and we get to hear you all vent about what's going on in and around your community or the free Karen Read, the Karen Read Trial 2.0. I can't wait to hear all of you on Sunday rant and, and flip out about that. So thank you again also so much. I think I had one membership member here that sent Scooter, look at this 9-month membership, says you rock, Brian. Well, you all rock. You rock. And Norman's Corey says, great fucking show. I appreciate that. And what I'll do is after this post down in the comments, if you want to watch the hearing without my commentary and the stop and pauses, you can do that at your own leisure. But that's what we do here. We talk live, and that's why this is called Let's Talk Live. And that's why my channel is called LTL Media, because it stands for Let's Talk Live. I do want to make just kind of present to everybody. I think at some point, and I'm making the decision here over the next couple of days, the channel will still be LTL Media. The company will still be LTL Media. But I think on my tagline on my website, I'm going on my YouTube channel, I'm just going to drop media and it will just be LTL because I've kind of come by that name. And I think that's what we're going to start doing going forward. But I haven't made the solid decision on it yet because I don't want to give up the name, because sometimes when you give it up, you don't get it back if you want to go back to it. But let's see. Scott, thank you so much. 16-month member. The 16-month member, great friend, and a wrench, a moderator, and says congrats on 40,000. Thank you, Scott, for being here. Alexandra trying to pump the chat. Look at this. We only need 7 more likes. Smash that like button. Let's get to 1,000 as we head out here. All right, everybody. We're going to head out. Iron City Choppers, a new YouTube member. Yes, everyone does call me BLT. Yes, I am the BLT, but this is LTL. When we talk live, that's what we do. All right, 3 more to get to 1,000. Can we get to 1,000 before we go? Let's see. Mary says it shows 1,000. Let's see. I see 1,000 and 14 downvotes. I always love the downvotes too, because it's probably the McAlberts. Is there 14 of them? If we count their clan, it's probably all of them. But people don't realize when you downvote, that helps the algorithm too. So thank you for downvoting as well too. All right, we're gonna head out of here. I'm tired. I have to work tomorrow, unfortunately. I love all of you. Thank you so much for coming in and hanging out this evening and celebrating with us. 40,000 subscribers. Fucking, that's so awesome. It's so cool. And we'll have more. We have a lot to go. We have a long trial. It's going to be a battle. And we need to make sure that we free Karen Read. All right, everybody. I'm going to head out. Have a good night. Peace.